Hello everyone, and thanks again for joining us today for this masterclass on dispute resolution. This is another masterclass from our autumn season, and we've got a fabulous panel here today. So we hope that you enjoy this masterclass and can get involved with the conversation using the Q&A function in Zoom. So we always start our masterclasses with our learning outcomes. So by the end of this masterclass, you should know how to break into this practice area, know what the work of a dispute resolution solicitor involves, and understand the key issues facing the practice area right now. So before we get going, I'm just going to run through some quick house rules. So first and foremost, please do use the online question tool, as I said, to post any questions that you have. I'll be posing these to our speakers as we go throughout the session, so please do get these in as early as possible. If you have any audio or visual problems as well, please use the Q&A function, and someone on the LCN team will be able to help you with that. This masterclass will be recorded, and the recording of the session will be sent to all registrants after, and it will be available on our YouTube channel very shortly as well. You can also check out our previous masterclasses via our YouTube channel, and next Thursday at 3 p.m. we're hosting a brand new masterclass all about pro bono. A link to sign up to that will be in our follow-up email, and you can also catch our last masterclass of the year, which is all about employment law, on the 16th of December at 1 o'clock. Talking about events, we've recently opened submissions for the 2026 Student Law Society Awards. So please do take the member survey to let us know how your society supports you, and they could be up for an award at the award ceremony next March. Okay, so let's do some polls. I'm just going to ask all attendees if you can answer the question on the screen, so our panelists can get an understanding of who has joined us today. So what stage are you at? First year law student, second year law student, third year law student, non-law student, postgrad, or in work? We've got a few first years and second year, third years, but majority postgraduate and in work, which is nice and interesting. Share those results. Next up, we want to find out how much you already know about dispute resolution. Fabulous. And majority saying a little, a few saying absolutely nothing, but we don't have any experts other than our wonderful panel here today. Okie dokie. Right, to get us started, I'm just going to get each of our panelists to introduce themselves. So just looking at my screen, Stephanie, I'm going to come to you first, please.
Hi, everyone. Really pleased to be part of this masterclass. I am Steph Lee. I'm a partner at Travers Smith in the dispute resolution team. Travers Smith's a full-service law firm based in London. We're around about 90 partners and 350 or so lawyers.
Brilliant, thank you. And Jamie?
Hi everyone, again, really pleased to be with you today and for this session, which is, I think, the third time I've done this one, so nice to be asked to do it again, alongside Stephanie as well. So I'm a partner at Trowers and Hamlins in the commercial dispute and resolution department. I broad commercial and corporate litigation experience with a lot of fraud type work as well. Travers and Hamlins is a full service law firm, international law firm, I suppose, with offices across the UK and primarily the Middle East and Asia.
Brilliant, thank you. And Laura?
Hi everyone, thank you for having me. So my name is Laura Woodward. I'm a senior associate at Mills and Reeve. I work in the property litigation team, so I specialise in property related disputes. In terms of a little bit about Mills and Reeve, so again, full service law firm operating out of 7 offices across the country, and I'm based out of our Birmingham office.
Brilliant, thank you. And then Paul.
Hi everyone, I'm Paul Maddock. I'm a director at DDF in the dispute resolution team, dealing with a full range of commercial and corporate disputes. I'm also the firm's graduate recruitment director, so I look after all our pathways to qualification, from vacation schemes, apprenticeships, training contracts, etc. I also chair the Law Society's LGBTQ+ division, looking after different D&I proposals and initiatives that we do from the Law Society. In terms of DDF, we have over 4,500 people from offices across the globe, from Canada right through to Australia.
Brilliant. Thank you all very much for those intros. So just to get us started, I thought it'd be nice to do a quick introduction into dispute resolution itself. So what does dispute resolution mean, and aren't all legal cases disputes? Jamie, if we could come to you for that first one.
Yeah, absolutely. So I think I always like to start this with a general position of, because we do dispute resolution, we are often seen as just litigators, i.e. there's two categories of things that ordinarily find their way over to our desks, and that is A, when something has gone wrong, or B, when something is about to go wrong. But I like to think that we're a lot more than that, and that's whether it's commercial, corporate, or property litigation, or any fortunate disputes. I like to see this really as an extension of more risk avoidance. Risk management is a huge part of it. So all disputes, litigious in their nature, they can be, but I think if we can get involved at an earlier stage, we actually can add a lot more than that. And so my practice area historically, through to now, has always been working very closely with corporate, commercial colleagues, and if things start to need to be kind of redirected to avoid a dispute happening, that is where I like to get involved. We can be a lot more effective actually at that stage than simply dealing with it when it's all exploded and everyone is very angry with each other. Because I think a lot of the time, otherwise, litigators are seen as a distressed purchase. We get it, but there's a needs must. If we get involved at the right stage, we can.
Brilliant, thank you. And I'm sorry, Jamie, were you going to say something else?
No, not at all.
Okay. So Stephanie, Jamie mentioned there maybe the different stages that you might get involved. Could you just talk a little bit about the different types of disputes that you might come across in your day-to-day?
Yes, and I could take a full hour talking about that, because the beauty of dispute resolution, or certainly the way dispute resolution works in my firm, is that it's a very broad practice area, and that goes very much to the heart of what I love about it and why I chose to make a career of it. The work is very, very varied indeed. What every matter has in common, to Jamie's point, is that they are contentious in some form or another. There is says it on the tin, dispute brewing, but that dispute can be between a variety of different commercial parties. It could even involve individuals on a whole range of different legal matters, and indeed engaging different underlying facts. So just to give everyone a flavour of what my diet of work looks like right now, I'm working on a very large-scale, high-profile, complex fraud claim for a tech company, which is worth over $1 billion. But I'm also doing an arbitration for a private equity firm, a whistleblowing investigation for a corporate client, and a warranty dispute in respect of an M&A transaction that has gone wrong. So each of those look very, very different indeed. And over the course of my career, I could add another sort of 50 examples into the mix that also look different. So it's a broad practice area.
It found it indeed. And Laura, did your area look different? Obviously, you work within property as well.
Yeah, so I suppose the slight difference with me is for me, there's always property or land at the centre of what I'm dealing with. But I would say that, just building on what Stephanie has said, even when you sort of are in a more specialised area like property litigation, it just opens out again into a whole host of different types of disputes that you can have. So to give some examples of things that I've got on my desk at the moment, I've sort of got a large scale potential claim. As Jamie said, it's only a potential at the moment. We're trying very hard to avoid it becoming anything else. which could be a liability of the client into the hundreds of millions if the whole leasehold structure falls down. But then I can also be dealing with things like I've got another one where there's a large scale development taking place and there's restrictive covenants that will potentially be breached if that development does take place. So that just shows that that's two matters. Both of those fall under the ambit of property litigation, but actually they are vastly different in terms of the different points we're considering and also the law that underlies it as well.
Brilliant, thank you. And Paul, we've spoken about the kind of various different types of disputes that might occur. Could you just outline the different dispute resolution options?
Yeah, of course. So there's multiple different dispute resolution options. I suppose the sort of main three to look at, will be mediation, arbitration, and litigation. So sort of starting off with litigation, this will be the process of going to court when the parties can't agree between themselves how to resolve or move forward in a set of circumstances. So litigation would be going through a prescribed process, a court process, and depending on the type of dispute, there'll be different stages to that process, whether that is witness statements, disclosure of documents, case management hearings, etc. It will depend on the nature of what is being articulated and what is in dispute between the parties. And different types of disputes will have their own rules in terms of court process, but it'll ultimately end up at a position where a court or a judge will determine who's right and who's wrong. Looking at arbitration, it's a more flexible approach, so it's a non-corporate approach. It's where the parties agree to go through an arbitration process where an arbitrator will be appointed and they will have a legally binding decision at the end. Because of the flexibility in terms of arbitration, because it's not a court process, the parties can keep things private. They can usually make it, it's meant to be sort of cheaper and more flexible in the circumstances, and often suits particular niche areas or international areas, given the flexibility of approach. And then sort of final one would be, as I said, mediation. Now, mediation isn't necessarily a separate path because you will mediate alongside litigation or alongside arbitration in most disputes. But that is where the parties will appoint an independent mediator, so a third party, who will try and facilitate a resolution between the parties. It's completely flexible in terms of approach. You could do it virtually over Zoom, as we're doing now. You can be in person. And the whole point is to try and find a solution to the problem and to enter into a legally binding agreement. Unless you enter into that legally binding agreement to settle matters, there is no impetus on the parties to be bound by anything that is discussed in the mediation. So there's just three options, and there's a few others for dispute resolution processes.
Brilliant, thank you. And while we're talking about resolution, one of the attendees has asked, without giving away any sensitive details, can you give some examples of imaginative or unexpected ways that a dispute you were involved in was resolved?
I was just typing. I've half typed an answer, but I can expand and Paul, and then feel free to carry on, I suppose. I suppose it's not necessarily imaginative or unexpected way, because every case is different, and the key for me is understanding or trying to understand what the underlying issue is. Because a lot of the time it's not the actual claim, it's not the dispute, it's not how someone's running the company, it's much deeper than that, particularly in the, I've historically done a lot in the owner managed business type sector, so there's normally lots of kind of personal issues that kind of fall into the mix. But I think understanding the real underlying issue for both parties, I think that's really key, to try and see it from both sides, can then often get you to a much earlier resolution than if you simply focus on the nature of the claim. So, even where someone is, the other side's really irate about you because of a situation, you completely deny it. Trying to take that step back and say, okay, well, why might they think that? What was it that kind of, because they genuinely believe that position. So what makes them genuinely believe that position? And like I said, a lot of the time it is these kind of underlying issues that the court can't necessarily resolve. The court's not going to resolve, certain issues that are ultimately driving the clients through the litigation. And I think trying to understand that, and it's hard. It's hard sometimes to get your own clients to get to that point, let alone trying to understand the other side. But I think if you can do that, we've seen settlements be reached between the parties on really obscure basis, in terms of working together in different ways, or dividing assets, simply that weren't even on the table, weren't even part of the actual claim, but because it's giving the parties what they both need. So yeah, not necessarily unexpected, or imaginative, maybe not, but I think that for me is a key starting point.
Brilliant, thank you.
Yeah,
Anything
I
to add to that?
completely agree with that. I mean, just by way of example, it's not particularly imaginative either, but just to further illustrate the point, actually something like an apology can go a very long way. To Jamie's point about what's the driver behind the litigation, what do people really care about? Is there huge sort of personal investment in it? We tend to think in pounds and pence and what is the settlement sum, but actually it's humans that are involved. Even if you're litigating, as I generally do for corporates, those corporates are run by individuals, and sometimes if your client can see their way to apologising, or the other side can do that, then that will unlock a huge amount.
I sort of add to this. I'll keep it really short. I had a really odd situation. I'll say odd rather than innovative, and it wasn't my innovation, shall I say. Recently, with an estate, so it was an estate dispute over a sort of deceased property, and it's worth tens of millions of pounds. This estate, but there was a way of structuring the estate that, if you structured it, the charges and the tax would have vanquished, and there'd be more money for everyone. Now, if we went to court, that was never an option for the court. It was quite binary whether the will was valid or invalid. We're going to mediation. The parties were able to agree a structure that meant everyone got more money. So the dispute was how we split the additional money. But if we would have gone to a court, everyone would have ended up with less than if you went to a mediation approach with a more creative, flexible trust structure. So this was a real situation where going to court was in no one's interest. No one was going to come out with it with more money, as opposed to working out a very sensible tax structure in the background.
Brilliant, thank you. Oh, really interesting examples. So thank you so much for sharing. Laura, just coming to you next. I wondered if you wanted to just kind of talk about how specialist your area is compared to the other panelists.
Yeah, I think, not to put words in other people's mouths, but I think probably my area is a little, I have specialised a little bit more because I am more focused on the property element. So, like I said, any dispute that I deal with will have an interest in land at the centre of it. But I don't think that means that you're limited in the type of work that you're doing. So whilst I have my own clients with their own disputes, I do a lot of work, for example, with our insurance team. So, for example, for the insurance team, when they're acting in professional negligence matters involving large-scale property transactions that have unfortunately gone wrong, actually we're there to provide the specialist advice on what should have happened or the strategy that might be from the property angle. And the same with corporate support as well. So if you've got a corporate entity that is looking to buy out another entity, very often there is a property involved or there is a property element. So whilst you are specialised in what you're doing, it doesn't limit you in the other areas that you're able to practice in as well.
Brilliant, thank you. Jamie, I just wondered if you could share some examples of the types of client that you might end up working for, and kind of what sectors those clients sit in.
Yeah, absolutely. So a really, I suppose, broad spectrum. I do a lot for historically, I suppose, more corporate related clients. I've done a lot in the manufacturing and engineering sector. I'm based in Birmingham, or the West Midlands, really huge manufacturing industry here, so that's always been a big area for me. But realistically, we're very sector agnostic in terms of the types of clients and types of sectors that we deal with as well. So a dispute can arise in any circumstance. So I've over the years I've done quite a lot of shareholder disputes, and that's acting for, in essence, individual shareholders in corporate organisations. Equally, I've acted for a lot of corporates in relation to their dispute with other corporates. So they're I suppose the two main ones. But in all sorts of arenas, and in relation to all sorts of issues. I used to historically did some construction litigation as well, because it kind of naturally flowed from some of the more manufacturing engineering stuff that I was involved in, and a lot of technology and construction court type cases. So it is really mixed, and I think, you know, unless you do specialise in, I'd say in litigation, the main areas that people look to specialise in is, you know, corporate commercial type litigation, i.e. the broad, I would say it's kind of the more broad area in terms of, you know, anything falling in that remit. You've then got contentious trust and probate is probably another area, and then property litigation. I've excluded other areas like IP or insolvency. They normally sit more naturally with those kind of underlying departments. So it is broad, but that for me is the variety that keeps it interesting. And also, I didn't like land law, so property wasn't going to work for me. But, you know, a lot of the work we do still has property elements, and you'll generally find that litigators work across the pieces, because, you know, a lot of big corporate litigation, whether it's an M&A dispute or anything, will quite often have property-related issues. So it's very much interlinked anyway, and so you generally find litigators work very closely with other litigators in more niche areas as well.
Brilliant, thank you. And Paul, do you find that your clients kind of in similar areas, or do you have anything else to add to that one?
Yeah, definitely. It's a real mixed bag in terms of what we get from clients. A lot of maybe the way to look at it is like where the sources of clients come from in terms of generation. So we'll have a number of clients that will be internal referrals at D2F, so they will be a client of a different team. You don't. Certain clients hopefully will not need us very often. Hopefully you will need a litigator once in your business career. You won't need them very regularly. So we can often be quite symbiotic to other areas where we'll provide some risk management support. And when something gets into the dispute resolution remit, it will come out to us in those circumstances. We'll have other clients that are full service for a particular law firm, and they will instruct us because they have a number of our type of disputes quite regularly. Some people will contact you through networks that you know, contacts, etc., etc. So it's a wide remit in terms of how you can be instructed, and therefore that leads to quite a wide remit of types of clients, types of sectors, types of industry, etc.
Brilliant, thank you. And Jamie, Paul spoke earlier about the different types of resolution, but how do you get to the point where you understand, or how are you trying to work out what it is that your client wants, and whether, like Paul was saying, going to court is the right option? How do you understand what your client wants to achieve, and then how to get to the resolutions?
That is $1 million question. And looking back at your opening question, I would tick the not an expert box for that. No, it's a really difficult one. It goes back to the point I said before about trying to understand what's driving the litigation. The key in any dispute, to get to any form of resolution, whether that is court mediation, you know, or whatever, is understanding what the client's objectives are. So try and understand what the underlying issues are, because that helps us as litigators and might help us with our rapport with our opponents to try and figure out where the parties need to get to. But to understand what the client ultimately wants, you know, I have dealt with litigation where the client's intention is to ruin the other side. Not pleasant. We've all been there. We all know the type of clients, but it's a type of client, and sometimes that is the objective. Some clients' objectives are to delay for as long as possible. Others are to resolve as soon as possible. So understanding what the client wants to achieve and why, because sometimes there are genuine reasons for that, you know, as well. And then doing what you can to, I suppose, put that into practice. But, you know, there can be an ultimate challenge with litigation in that we can only go so far, and it can be really challenging. I'm sure we've probably all been in that scenario where we know what's in the client's best interest, and we'll be advising them what's in their best interest. They don't always listen, because it can, like Stephanie said, it can be very personal. What I generally say is that, you know, court for certain cases is the only real way to, you know, certain types of cases, but actually rarely is that really the case. I think, you know, litigation is notoriously difficult. None of us would have jobs if it was that easy to say you're going to win, the contract's quite clear, it says X, or the lease says Y. You know, we wouldn't have jobs if it was that straightforward. So there's always a shade of grey, and therefore when you get to trial, there is always a winner and a loser. And so, getting clients to understand and actually understand and appreciate that risk, I think is also really critical. And some don't see it, some don't want to see it, some don't care about it, depends on their financial position and lots of other factors. So, trying to understand the objectives and understanding the objectives if it goes wrong is another way of looking at it. And that's common in mediation, where they say, look, your best case is going to be X and your worst case is Y. Mentally, the client's position on the best case is normally better than the best case, and definitely not as bad as the worst case. But when you understand those kind of potential parameters, it can make things that look quite unpalatable suddenly look quite palatable. Trying to get them to understand, and for us to understand them as well. Trying to find that balance is hard but really important.
Brilliant, thank you. And Jamie's touched on this slightly, Stephanie, but I wondered if you could talk a little bit to how much of the work is like putting these solutions in place, and how much is it you trying to convince the client or persuade the client that this is the right approach and that they should take?
Yeah, I mean, certainly, actually, my job as a partner is probably neither of those elements necessarily. I mean, I obviously do both those elements, but the bulk of my client-facing work is actually conceiving of the strategy in the first place. That's the hard part. I mean, it really goes to what Jamie said. You have to assume that everyone in this sphere is a very good lawyer. There's no right or wrong answer to the question, and we're not just there to parrot the law. We're there to think strategically, think big picture, look at the commercial drivers, and then come up with a strategy at the outset of the matter, and then importantly pivot and adapt that strategy depending on what the other side does. I often describe it as akin to a game of chess. You can't be sort of set in a particular pattern. You have to respond to the movements of your counterparty. So that, to my mind, is the most important part of my job, the strategizing. Once I have done the strategizing, there's obviously a huge amount of work to be conducted in implementation, and I try and push that down to the more junior members of my team as much as possible to do the actual doing. In terms of the sort of client engagement piece, and whether you are sort of telling a client what to do or persuading them what to do, I think really the best client-lawyer relationships are those where there's mutual respect and a healthy amount of challenge on both sides. I will never tell a client boldly what to do because they know their business, it usually is a business, much better than I do, and they know their own motivations much better than I do. So what I often present them with is a range of options, and then enter into a dialogue with them to work out what suits them best in the moment. And I want them to question me and test me and challenge me, and again, that's all part and parcel of the job and what makes it fun. So that too is an important part of it, but it's neither sort of telling the client what to do or convincing them. It's going along with them on the journey, I think.
Brilliant, thank you. And Laura, Stephanie mentioned there kind of the strategy element of the work. What factors would you say you're looking at when you're building that strategy?
I think we've probably touched on some of them already. It's fundamentally, it comes down to what the client's objectives are. And I think just thinking about what your client wants to try and get out of it. So, for example, I act for a lot of universities. Universities often have quite a particular outlook with very often their charitable responsibilities, but also, their wider research responsibilities. I also act for a lot of pension funds. They clearly are going to have a very different view in what they want to get out of litigation if they are going forwards to litigation. So it's being really aware of what your client wants to try and achieve. And then I think sounds quite like Stephanie. I always like to have sort of a big picture at the beginning. What are we trying to achieve, and what's the sort of overall end goal? But you have to remain flexible. And like Paul was mentioning, at each stage of litigation, when you have witness statements or disclosure or expert evidence, you need to be able to look at your strategy again and think, actually, does that need to change? Is there a factor that's come in that has changed things? And I think just keeping up a constant dialogue with the client. We all know that litigation can sometimes take years and years to get through, and a client might start at the beginning of a 5-year process with one view, and actually commercial pressures have changed, or things may have changed at the client, which mean that their strategy has changed, and you then need to pivot with them and move with them as they want to. So I like to have an overall view, but you do need to remain flexible throughout when you're coming up with your strategy.
Brilliant, thank you so much. There's quite a few audience questions coming in, so I'm just going to hop over and go through some of those. Paul, I wondered if I could come to you for this first one. Someone has asked, how are settlement offers used strategically during the course of a dispute resolution process?
Yeah, absolutely. So I think there's two main ways that I sort of see settlement offers. One is to broach the gap between the two parties. And putting a sensible settlement offer out there can entice a conversation, can sort of elicit whether there is something to be had at this stage of the litigation, depending on where you both are with your fact patterns, how you've presented your case, etc., to get the parties to come together at that stage before further cost or further risk is undertaken. And that is, I think, a settlement offer that's sort of commercial and de-risking in nature. The other approach, I think, to settlement offers, and by the way, some offers will straddle both, but the other is for cost protection. So you will make a settlement offer on the basis that it has got a level of risk to the other side for not accepting it. So the way it generally works in court proceedings, if you make an offer and it's on without prejudice basis, i.e., the court will not know about this offer during the sort of index trial that we're talking about. Once the court has determined, and this is again looking at litigation, once the court has determined who is right and who is wrong, then the parties will show the without prejudice correspondence. So they will show what they did during the conduct of the litigation. And that's when the court is determining what costs should be awarded for either party. And during that process, if you are the party that has been victorious or even a loss to some extent, and you can show that you did make a sensible offer that was better than the end result, the court will then usually penalise the other party in terms of cost recovery. So making a sensible settlement offer early doors can provide that risk to the other side that moving forward through the litigation, if they are to be unsuccessful, there is a cost risk against them. So as I said, I see settlement offers or offers generally in two camps. One to sort of start the ball rolling in terms of engagement between the parties, and one to provide that cost protection. And offers can be both, or they can be one or the other. Depends on the nature of the dispute.
Brilliant, thank you. And we've spoken briefly about kind of how you will work within dispute resolution, your roles. Somebody has asked, Jamie, and I wonder if I come to you for this one. Someone has asked what role trainees play in dispute resolution. Is there opportunities to have direct contact with clients, or is it mainly researching and drafting?
Okay, so I think it very much depends on the type of firm that they're training at and the type of work that they're exposed to. The joys of litigation is you never quite know what's going to be kicking off when you have a trainee in the department. So if I look at the trainees that we've had, their experience, the experiences of different trainees will have massively varied depending on whether we had the course of last year. Last year we'd had a 10-week trial and a 2-week trial taking place within a 3-month window. And that was just the Birmingham team. So the trainees at that period had huge experience in terms of trial preparation, conferences with counsel, client contact, preparation of trial bundles, attending court, so that type of stuff. Other points in time, it might be more drafting of witness statements, disclosure. It can really vary. What I always like to try and do, particularly those that are then the latter C's that we're really interested in going into litigation in the long term, is try and get them exposure for the early case assessment type piece, because that a lot of litigation is a process, and like lots of other areas of law, that process is what happens and what you do, and understanding it is pivotal. In terms of leading up to qualification, what I like to try and expose trainees to is that initial thinking. Here's a problem. How do we go about it? It goes back to Stephanie's point, strategizing. What is the issue here? What's the client want to achieve? How do we get there? What are the underlying issues? What are the underlying claims? What legal claims are we looking at? And that piece. So I think it can be really, really varied as a trainee. And certainly I look at the trainees that we've had, they've had lots of different experiences, but some have had experiences in really big cases, and others have had probably more of the other type of work where they're getting involved in that early kind of case assessment, looking at it, trying to understand the issues. So like any seat, it can be varied, but I think if I'm a trainee, what would I want to get? It is exposure across as much of it as possible. What I don't like doing is ending up with a trainee that's done 6 months worth of disclosure for one case. Like, that's not helpful. Not helpful for them, not helpful for us for the long term.
Brilliant, thank you. I'm just going to combine one of my questions with one of the attendee questions as well. So someone has asked about the general volume of your workload. So Paul, we were going to chat about the workflow and whether there's kind of crazy peaks and troughs. They wanted to know about like the pace of work itself and how long a dispute might last for, and that sort of thing.
Yeah, how long a dispute may last for is a piece of string question. So it's very, very the shorter the better is maybe the way to look at that. But in terms of the sort of crazy flows of work, it can be a little bit unpredictable with litigation because clients don't plan disputes. Disputes come out of nowhere. Disputes come out of left field, generally speaking. So on that basis, we don't have a pipeline of work, maybe as some other teams may be able to pipeline deals or transactions. Our work tends to be, it just creeps up out of the blue. Equally, the other side of the track is also correct. The disputes can disappear all of a sudden. So a settlement can come out of nowhere, or a client can lose their appetite in terms of a dispute. So disputes can end quite quickly. So as much as you can get a peak, you can get a dip very, very quickly in litigation, beyond anyone's control. Certain clients and certain industries may have more of a pipeline of instructions. So if you work with certain sort of big banks, for example, big telecoms company, they may be able to pipeline their instructions a little bit, but that's just a consistent volume of instructions. That doesn't lead to a consistent volume of workload. So in terms of how a sort of a cycle of dispute resolution may work, you can find that you have particularly busy periods when you're going through those court directions, so arbitration directions. So on the lead up to a big trial or lead up to a big disclosure deadline, you can have peaks at that point. I do tend to find that dispute resolution, because you have key deadlines when you're in the litigation sphere as opposed to sort of the risk management side of things, you can have a bit more oversight on what looks like it's going to happen. But that, as I said, it can be unpredictable because even the best laid plans can go awry last minute.
Brilliant, thank you. And Steph, I wonder if I could come to you next, and if you could talk a little bit about how international the work is, if there's opportunities for international work, or is it primarily domestic, or maybe a mix?
Yeah, so obviously this will depend on the firm in question. Travers Smith is firmly a London-based firm. We have our primary office in London. We've got a small outpost in Brussels, but we are an international firm in the sense that we do a lot of international work, and we have a very large international client base, and certainly more than 50% of the work I do, quite considerably more than 50% of the work I do, touches on another jurisdiction in some way or another. So, of course, I am only licensed to practice English law myself, and I only practice English law, but I have a lot of exposure to work which is international in nature. And just to explain what that might look like in a litigation context, it's not uncommon for me to be involved in a piece of litigation here in England, so before the High Court in London, but where there are also parallel proceedings in respect of the same subject matter in a different jurisdiction, wherever that may be in the world. I'm doing one matter at the moment where there are live proceedings in England and in France, and another where there are proceedings here in England and also in California. So that's how the sort of international aspect can come in. So we at Travers don't have international colleagues ourselves. I don't have Travers Smith lawyers sitting around the globe, but definitely every week, I am inevitably working very closely with lawyers in different jurisdictions.
Brilliant, thank you. And I think it's kind of clear that the work varies between firms, teams, etc. Laura, I wondered if you could just talk briefly about what a typical day might look like for you. And I'm sure there is no typical day, but you could just talk briefly about what that might look like.
Yeah, I'd say definitely no typical day, and I think that's something which can be a challenge, but is also what keeps litigation interesting. Is sometimes you can have a lovely plan and then something happens that changes all of that. So a typical day for me, I can run through what I've got on today and what I've had on today, just to give an idea. So I've had a call with a client to discuss an adverse possession matter this morning. So we've got some tribunal deadlines coming up. So looking at our strategy around those and dealing with the other side. And then I've got a settlement agreement to review for a dilapidations matter. So we've had comments back from the other side. So looking at whether we agree with those and taking the client instructions. And then I have a pre-action letter to draft as well on a leasehold dispute. So nice and varied, but a mixture of client contact. I'd say that I have client contact at least once a day, if not several times a day, whether that's on the phone or having Teams meetings with them, but also sort of your own work as well, where you're drafting documents or you're supervising more junior colleagues as well.
Brilliant, thank you very much. We're going to come on to a case study now. I can't believe it's nearly 1:45 already. So Paul is going to kind of briefly just chat about a case that we've worked on, who was involved, what were the problems and then the outcomes, and how you were involved in that.
Yeah, absolutely. So I'll save one from the blushes, so I won't name particular characters in this. And like all litigation stories, it started with a phone call from a client on a Friday evening, as we'll probably understand what that feels like. Now, this was a particularly testy set of circumstances for the client, as one of the accounts individuals had gone on holiday for a 2-week period. And during that period, when they'd gone on holiday, someone else was reviewing the invoicing process. And I'd noticed that certain invoices that had been paid a month earlier had been re-invoiced the next month. So this led to the interim individual who's covering the holiday period to analyse what had gone on, and had noticed this pattern of behaviour had happened for a long period of time, where an invoice had come in the month after an invoice had been paid. But what had happened is the previous invoice and the duplicate invoice had both been paid in these circumstances. So the client, in essence, for many years had been double paying every invoice that had come in from a particular haulier. So the client was quite concerned about this and therefore spoke to us. So it was a case of analysing what had gone on and trying to get to the bottom of this huge red flag that was hitting the client at the end of the week. Now, the first step was sort of forming a DWF team. So we had a partner, we had an associate, and we had a trainee assisting to start the ball rolling. And once we engaged with the client over the space of a weekend, the client was very concerned. Once we engaged with the client, we started to be able to put a fact pattern together of what had happened. And what had happened was the individual in the accounts team and his friend at the haulier had a scam going on where they would double invoice every haulage removal from the company. The client then analysed what that looked like over the decade that had been going on, and it was millions of pounds of double invoicing that had occurred during that process. So at this point, we got counsel, so we got a barrister involved at this stage to help with the strategy and the overall structure of what we were looking to do. Now, one of the first things that you do in any litigation is determine, is it worth it? is there a pot to recover funds from? Now, our concern here, this was a pretty junior member of staff who'd amassed millions of pounds for a fraudulent scheme over a decade. And our concern was that these assets may be distributed, disseminated, or just dissipated. And we had other, I won't sort of go into it because I'll take too much time, but there was other red flags in terms of this dissipation. So what we decided to do was get a freezing injunction out to freeze this individual and his friends' assets. So that is an initial stage, generally in litigation, that you do without notice to the other party, where you will freeze their assets pending the resolution of the dispute. It's very draconian, it's very expensive, it's very time consuming. So it's a weapon in your arsenal that you don't use particularly often, but when you do, you've got to be absolutely sure that getting a freezing injunction is fit and proper for the individual case. We were successful. We froze this chap's asset and his friend's asset, and then we were able to proceed with the litigation, trying to recover the ill-gotten gains in these circumstances. So the team had to expand a little bit. So we had to get experts involved. We had to get a forensic accountant involved to go through the accounts to try and analyze what the actual value of the duplicate invoicing had been. And then we continued through the litigation process. We were successful. He was fraudulent. We were successful, and we got an order against him, and we enforced it against some of his property. Some of it was never satisfied in the circumstances. In conjunction to this was also the criminal aspect of at what point do you report this individual to the police? And again, that was, I sort of won't go to the ins and outs of it, but again, it was looking at whether you do that early on in the proceedings or whether you wait till you've got a resolution and hand your file over to the police in the circumstances. So it was a very positive outcome for the client in very difficult circumstances. They didn't recover everything, but because of the sort of quick action, because of the red flags that they were able to spot, and because of using tools like a freezing injunction and strikeout applications, we're able to try and truncate the process and secure assets that we could recover against early doors in the process. Client was very happy, albeit embarrassed about the circumstances. So it was a difficult one, but it was one where the trainee was involved from initial call with the client on the Friday evening right through to the sort of resolution. And because there were so many moving parts to the matter, the trainee got really under the skin of the matter and was able to assist throughout.
That sounds so interesting. Thank you so much for sharing that, Paul. I guess Jamie, Paul's spoken a little bit there about obviously when he got the call for the case on the Friday afternoon, evening. I wondered if you could talk a little bit how in this area of law you actually go about getting business.
Yeah, I think it's often a big question that's asked because unlike, say, corporate, you've not got an obvious source of work, as in, it's not like you're pitching for the same type of thing with the same type of people. So I think there's a few different elements. Firstly, I think both Stephanie and Paul touched on them earlier as well, actually. There's the internal aspect, so your internal market, because whatever firm you're at, there will be an internal market of some degree. And so naturally getting litigation or disputes that are kind of brewing sent over to the litigation team from whatever department it might be. It might be an employment related one if it's a breach of restrictive covenant, bad leaver type situation. It might be a commercial contracts dispute that's coming to a commercial team, corporate M&A related. So they're just a few examples of the internal. For me, the way I've always approached it, I've always enjoyed business development anyway, is the external market is huge because every single organisation and people out there will have the need at some point in time, probably for some kind of dispute advice. So I work really closely with the external market, particularly forensic accountants. Conflicts, other law firms is a huge source of work. Barristers' chambers for the same reasons. Certainly in Birmingham, Laura will probably know, the Birmingham legal market is, or the Birmingham professional staff. It's one end of Cromwell Road to the other and a couple of roads back. So, we're quite blessed actually in terms of having a very close-knit, knowing that market well, because what you're really looking for, and this is the challenge of litigation, is you don't know when it's going to occur. You don't know when our skills as litigators are going to be needed. So you just need to be at front of mind. And it's really difficult to kind of be at front of mind all the time. But I think being out there, being seen, being known, mixing with the people that might be that first point of contact. Sometimes that point of contact bizarre. It could be the accountant. You think lawyers historically have never been the first port of call as a trusted advisor for particularly corporate clients. The accountants have generally had their foot in the door that little bit early because they're in more direct communication. So looking at those kind of avenues, you touched on the international aspect earlier. I do quite a lot of international work. We do as a team. We do quite a lot of cross-border disputes. We've got a big DIFC case that I'm not involved in, but the team are happening early next year. So knowing our international markets, their needs, and certainly in the regions, there's been a huge growth of, I think, because of I'd say primarily cost. We have lower charge out rates generally than our London counterparts, so that is an attractive proposition. But equally, that's opened up avenues for us, for people like me to get work out to some London contacts that I've had historically that might ordinarily have gone, we send this into the city. So it is really varied, but I would say look at your intermediaries, look at the people that you work with on cases, and be out there talking to people on a regular basis. I think that is the only thing you can really do in litigation. And it can be quite nice, nice breakfast, nice lunch, a glass of wine after work. It's not the worst types of events to do.
Brilliant, thank you. And I think also really important to touch on the various things that are happening in the various areas that you're working in. And obviously Laura being in property and the Renters' Rights Bill, just receiving royalers, and how has that impacted your work?
Yeah, so we've the Renters' Rights Bill received royal assent last week, and it's looking as though it's going to be coming into force in spring next year. So this is going to it's what the government's been referring to in brackets as sort of the end to no fault evictions. So this is nice now to have a little bit of certainty, I suppose, as to when it is coming into force, because we've been expecting it at the end of this year and it's now been pushed into next year. So we do now have that certainty. I think it's fundamentally going to change the way that perhaps the private rented sector is looked at as an industry and what landlords are prepared to do. So we've been trying to work with our landlord-based clients who've got large residential portfolios, which previously might have been a set amount, a set income stream for them, and that is not that that's necessarily going to change under the Renters' Rights Bill, but it will just affect the way that those properties are managed. So a lot of it at the moment has been preparatory work and trying to work with clients so that they can manage that risk. So what we were talking about earlier, there isn't a dispute yet, but we can see something coming down the track that might affect them. So how can we help them manage that? And now that we've got a little bit more certainty, I think there's probably going to be quite a few landlords taking proactive steps to make decisions to whether they want to get themselves out of this situation, and whether they want to try and sell their property or they want to try and recover possession of it before the act comes into force. So I think we're now moving out of the preparatory risk analysis stage more into the clients deciding what they want to do.
Brilliant, thank you very much. I can see, Stephanie, that you've been busy answering some questions, so thank you very much for that.
Putting my typing skills to the test, yeah.
As we've got 5 minutes left, I'm just going to turn to those questions now as well. So there's been lots of questions about the various skills needed to succeed in this area. So Stephanie, I wondered if you could just touch on that one.
Yes, and I think the interesting thing about some of the questions that I haven't answered, because I couldn't work out how to do so swiftly, is what do we need to be studying? What experience do we need to be getting? And I think the answer to that is maybe quite unhelpful, but don't get too hung up on those points, because actually you don't need to bring particular sort of expertise or experience to a firm with you. What matters much more to my mind are the core skills that we utilise day to day as litigators, and frankly, many of those core skills overlap with the core skills utilised by lawyers in different practice areas. My transactional colleagues and advisory colleagues. But to my mind, it is hugely important as a litigator to be able to communicate clearly. because so much of what we do is being analysed by an opponent who does not want the best for us. They're going to look to pick holes in everything we say and do. So you need to be really precise in your communications. Those are communications that ultimately might be considered by the court down the line as well. So I'm always looking for people who can communicate well, both in writing and orally. And then the second skill I would pull out is analytical ability, is probably the way I'd term it. And that is, what we do in litigation, normally a client comes to us with a problem. They don't know how to solve it. They don't really necessarily understand what's gone wrong, and they just land you with a huge amount of information. They'll give you that call on a Friday night, as Paul said. It'll be an hour and a half long. They'll tell you a load of stuff, half of which is going to be relevant, half of which won't be. They'll then send you a load of emails and WhatsApps, and you have to filter through those and work out what's relevant and what's not. And so it's an ability to absorb information, analyze information, and ultimately determine what matters, what's relevant in the given context. And as I say, you're not going to get that from studying IP law at university. You're not going to say you must do that. That'll give you the skills. Really, you can gain those skills in a whole variety of different ways by studying a whole variety of different things.
Brilliant, thank you. And I think part of that question is like then kind of applying it to the dispute resolution and propping it in your vacation scheme and training contract applications as well, not necessarily it being legal experience that you may need to kind of showcase those skills. Jamie, someone has asked what would you recommend they do now to get more hands-on experience within this type of sector? But I also wonder if we could maybe just twist that for the audience to have a think about maybe the non-legal experience that might be beneficial.
I think you go back to what Stephanie said. I think any experience. If I look back at vacation scheme students, trainees, etc., that we've had within the business that have sat within our litigation team, that I've gone, oh wow, they were good. It's not necessarily their ability to do a research task or their drafting skills. It is. I don't like saying like it's like a commercial nous. It's kind of an understanding. It's when they join a client call, they kind of understand what the client think. They're understanding why the client's saying something. They show a degree of empathy or appreciation for the issues. And it's not, like I said, I don't expect people to know the answer, or to know what strategy to apply. I'd like them to think about it, but I like to know that thought process is on the right track. So really, I think any experience, particularly any business type experience that they can get is great. But any experience where you are problem solving, where you are, and when you look at the kind of typical interview questions that people get, understanding those kind of, okay, so what's the issue? And that could be in any context. It could be working in hospitality. I worked in hospitality before. Throughout my day I got my national insurance card through to the day I finished uni. I got work experience in a legal team at one of the banks. I did citizens advice period, that kind of thing. But they all gave me something slightly very different. But as many skills in terms of dealing with people as I did in hospitality, as I gained other skills in the bank. So I think just whatever experience into that problem solving, that listening, that empathy, that understanding, that working with others. It's a very litigation is intense, like Paul said, it can run for years. You're dealing with people in a high level of stress on a regular basis. You need to be able to build relationships. So you can do that any job really gives you the opportunity to hone some of those skills. Maybe an unhelpful answer, but I think
I think it's easing the pressures, because I feel like lots of people we speak to feel like they need to have had loads of experience in a particular area of law or within a law firm, and it's just not the case. So I think it's always nice for them to hear that. So thank you both for sharing.
Keep up to date with the news. See what's going on, what's impacting society, because that impacts litigation as well.
Yeah. Well, I think we could probably sit here for another hour and or two and keep going. But the masterclass has now come to a close. So I'm just going to share our final poll just to find out what you have taken away from the session. So whilst you answer that, I'm just going to round up. So just another reminder to attendees that we'll be sending out a link containing the recorded session. So please do keep an eye out for that. And a survey will also be popping up once this masterclass has ended. So please fill that in and let us know how you enjoyed today and what other topics you'd like to see us cover in the future. A reminder to check our upcoming masterclasses on the events page, and just a huge thank you to our panellists for their time today. Just going to share the results. So lots of people saying they have a better understanding of what the work of a dispute resolution solicitor involves, which is great news. So thank you very much. Thank you to all of our panellists today, and look forward to seeing you all soon.